I'm attorney Ryan Pacyga, and I'm talking about the criminal procedure in the courts. Today I'll talk about a pretrial hearing. The purpose of a pretrial hearing is mainly to see if the parties are able to resolve the case. That means that you as the defendant and the prosecutor, if you guys can agree on a reasonable plea in a case. And some cases are in a position where really they can never come to an agreement, and some cases are just meant to go to trial. Other cases are worth each party settling because each party has some risk of not getting everything they want, and then you consider what might be a fair plea agreement under the circumstances. So it's kind of the first opportunity to realistically look at settlement negotiations in a case. And the reason I say that is usually all discovery isn't done until the pretrial hearing, and sometimes, frustratingly, it's not even done by then. But when you first have a case and you go to your first appearance, your lawyer usually doesn't have all of the evidence in your case yet. The prosecution hasn't been able to had time to send it all even over yet. So I don't think it's generally smart to try even considering resolving a case or settling until you have all the evidence. Because if the prosecution is even missing one small thing, or you don't hold out for that last piece of evidence, that can often make a big difference in how plea negotiations come. For example, there are many cases where I request the initial packet of discovery, sort of the basic police reports and everything else, and on their face, a lot of times everything looks right from a prosecution standpoint, but I can't tell you how many cases I've had where we follow up on additional discovery and ask for more than what's just kind of the standard packet, and that's kind of where the gold nuggets are in cases where you can find holes in the prosecution's case or serious problems with their case, and all of a sudden you're having a motion to have your case thrown out, or charges thrown out, or evidence suppressed, or your negotiating power is a lot better. So if you don't have all the evidence by a pretrial hearing, at least for my style, you really shouldn't consider resolving a case without that. But if you have a lawyer, listen to their counsel, but have that in the back of your head. If all of the evidence is there by the pretrial, then you can reasonably look at, well, what's a reasonable plea offer versus not, and that just takes an experienced lawyer to know kind of what is normal under the circumstances. Is the prosecution asking for too much in a plea agreement, or are they asking for actually less than they could get, and it's a good opportunity? Sometimes it depends on what judge is there. Oftentimes you get different judges at each hearing, and sometimes you're better off resolving a case in front of one judge that's a little more lenient than another. So that's something to take into account as well. And then, of course, some people just want the court process to be over, and that's your right as a defendant in a criminal case to end it whenever you see fit. It's not us as a lawyer. It's not our right to push you into doing something, either push you into taking a plea or push you into going to trial. We're there to advocate for you and to counsel you and help you make good decisions, but ultimately that decision about whether to accept an offer at a pretrial or not is yours as a client and not the lawyer's. If there's not evidence, then, or if the case can't be resolved by the pretrial, then your court case is going to keep going. And different states have different names for these sorts of hearings. They're in Minnesota, for example, they're called a Rasmussen or contested omnibus case hearing. Other states might call them a suppression hearing. So if it moves on, sometimes you'll have a hearing after to get certain evidence thrown out because your constitutional rights were violated, for example. Other cases, that's not a situation in the case, and then it sets for trial. So to recap, a pretrial is to see the first kind of opportunity it is to see if each side can come to an agreement on a plea agreement. And sometimes that happens and sometimes it doesn't. But if you can't come to an agreement, the prosecutors will sometimes say, well, our offer expires today, meaning if you don't take it, this offer is gone and it's going to get worse from here. And sometimes that's true, and other times it's not true. And then in other situations, prosecutors will agree to keep an offer open. And that means that they'll make an offer, but they say, we're not going to take it away today. If you don't take it, you can have a little time to think about it, or we understand you need more discovery, so we'll keep this offer here for you. We'll show you what else we have, and then you can make a decision at that time. So those are good questions to ask about a pretrial hearing, but that's the general procedure for a pretrial hearing. If you have more questions, my name is Attorney Ryan Pacyga. You can reach us at arrestedminnesota.com or at 612-339-5844.